sir.
Good morning, Your Honors. I'd like to reserve 3 minutes for rebuttal, if I may.
You may.
Good morning, Your Honors. May it please the Court, my name is Nicholas Slusher, a qualified law student under the supervision of Attorney Joy Radice, and appearing on behalf of the appellant Matthew Armitage. Your Honors, the judgment of the trial court should be reversed, as with the preceding case against Ginny Hale, and it should be reversed for 2 reasons. The findings of fact made by the trial court establish that Andrea Kasulis abused Mr. Armitage by placing him in physical restraint, in fear of physical restraint, and in fear of physical harm that night. And these findings of fact do establish this. My apologies, Your Honors. And these findings of fact establish a prima facie case sufficient to survive a motion for involuntary dismissal.
Counsel, same question asked in the previous case with regard to, you're not saying that we have findings by the trial court here of stalking, abuse. This case would need to be, if you're right on the ongoing danger, you're not disagreeing that this case would need to be remanded, right, for further determination, or are you?
No, Your Honor. Our position is that this judgment needs to be reversed and remanded, consistent with a clarification that the ongoing existing danger standard does not exist in case law nor in any order of protection litigation up to this point in this case.
The trial court would still have to make a finding that abuse occurred or stalking occurred consistent with the language of the statute on remand.
Yes, Your Honor. On remand, the trial court would make the determination as to whether domestic abuse and stalking occurred that night. We can see how that remand would go in the case of Murphy versus Janowitz, an analogous case that you've heard recently about in the preceding case. Like in Murphy versus Janowitz, Mr. Armitage was aggressively argued with that night. And like in Murphy versus Janowitz, Mr. Armitage could not drive to leave the house that he was in, which was one of the deciding factors in Murphy, where this court found it intimidating that the petitioner did not have a car with which to leave the house. In Murphy, petitioner was able to go to other rooms within the house to leave, but was intimidated and coerced into returning to this aggressive argument with respondent. And the court, I would say that this instant case is significantly more severe than that in Murphy. It rises to the standard which issued an order of protection in Murphy and then goes beyond due to the threats of fixing beatings tonight, which is established by Mr. Armitage in his initial petition.
Counsel, unlike the Hale case, there's no ex parte order of protection that was issued in this case, right?
No, Your Honor. In this case, Andrea Kasulis did not receive an ex parte order of protection.
Under the statute, then, we're not looking at a shall, we're looking at a may, aren't we, in terms of whether the ultimate order of protection is issued? Doesn't that put us in a very different place in terms of the appropriateness of considering ongoing, continuing danger?
We are looking at a may-shall distinction in this case, where we are on the may side. The quote from 605 is, if I may quote, Your Honors, that if the petitioner has proven the allegation of domestic abuse, stalking, or any of the enumerated legal theories in the statute, then the court may at that time issue an order of protection. If we were to read that consistent with Section 618, the stated legislative purpose, we see that the legislature foresaw instances where a hearing would be conducted without an ex parte having been issued before, and wanted to give the trial court the ability to issue orders of protection at that point.
Under A, to issue the ex parte order of protection, there's some sort of determination that's being made in terms of danger that's posed, right? And that's part of the determination of whether you're going to issue. Doesn't that attach to why there would be a distinction between a circumstance where you already have that initial determination, the shall issue, versus the may issue, where there has been no determination made of danger?
Your Honor, that runs inconsistent with the legislative purpose in 618, which, and I can quote, is that the official response shall communicate to domestic violence shall communicate the attitude that violent behavior is not excused or tolerated. The purpose of the Domestic Abuse Act is to, quote, recognize the seriousness of domestic abuse as a crime. And if we were to create a dichotomy within subsection B where some instances of domestic abuse are more tolerable or more excusable, then we would be shirking the last official response of the legislature.
Is it more tolerable or more excusable, or is it just taking in the sort of threat, danger aspect of the determination under A with regard to an ex parte emergency order and making it instead part of B? In a circumstance where that determination hasn't been made because no ex parte emergency order was issued.
Your Honor, if the legislature had intended for there to be a separate standard between the former and latter halves of subsection B, then they wouldn't have put the same standard written into both halves that the petitioners.
They didn't put the same standard, did they? I mean, they say shall with regard to one, and they say may with regard to another. They could have written shall in the last sentence of B, and they are drawing a distinction between the two.
They are, Your Honor, but we can see how this court has interpreted the differences between subsection A's and B's standards in Gibson versus Bicus, where it states that the burden of the petitioner, and I can quote, seeking a modification or extension of an existing order of protection under subsection B, has a less onerous burden of proof than that suggested by the respondent in Gibson. The party seeking a modification or extension only needs to prove the allegation of domestic abuse, stalking, or sexual assault by a preponderance of the evidence.
In drawing the distinction with regard to the less onerous burden that you're citing there from that quote, doesn't the language specify that it's in the context of a circumstance where there has already been an ex parte order issued, there is some order that's been issued and one that hasn't been issued? I mean, the lead into that block quote, I believe, draws that distinction.
The lead into that block quote, the sentences immediately before that quote is discussing the ex parte orders of protection. The reason why ex parte orders of protection have a more onerous burden upon them is because there's no chance for the respondent to argue their case. There's no chance for the respondent to be a part of this decision. And so the burden is upon the petitioner is increased because this is decided outside of a hearing and it has injunctive effects upon another person. It is for equity purposes in that case. And so here, where in subsection B we have a full hearing, we have the ability for both parties to make their case for a primary case, a case in chief for both parties, and a rebuttal. And so the burden does not have to be as onerous as a single-sided decision as with ex partes. The trial court based its decision on a misinterpretation of Delaney versus Chico. And I wanted to address this point the concerns of Judge Ushman that Delaney versus Chico was decided correctly, and it was decided within the discretion of this court if we look at it as a case of witness credibility. The introduction of the fear element is to discuss the need for an injunctive relief on the part of the petitioner. This court decided that 18 months going by and multiple actions within those 18 months to show that the petitioner did not need the injunctive relief showed that they were not in fear, and thus was an issue of credibility as to why are we even here, as to why are they asking for a petition at this point. Delaney versus Chico.
Where does that requirement come from in the statutory language, though, in terms of if Chico is correct, what would you point us to in the statutory language that suggests that's an appropriate consideration?
I would point you to the burden of proof upon the petitioner within subsection B, where the petitioner has to prove their case by a preponderance of the evidence, and one of the charges of the trial court is to determine if a preponderance has been met based in part upon the credibility of the witnesses offered. If the witness is saying they need something and showing evidence that they do not, then that is an issue of credibility.
Was there any real question, though, in Chico in terms of whether abuse occurred? occurred in that case, or the underlying predicate occurred?
There was no question that abuse occurred in Delaney versus Chico. The only question was the 18 months in the interim. As with this case, there's no finding of fact or of law that abuse did or did not occur on the part of the trial court's findings. And we are asking this court to reverse so that we can make that conclusion of fact that domestic abuse has occurred and that the petitioner has met their burden at the trial court level, consistent with the fact that the ongoing existing danger standard is not a meaningful standard that has existed before this instance and has no basis in case law nor in statutes, and that the need standard articulated in everything from Collins versus Ferris in 2001 to Delaney versus Chico in 2023 is proven by the petitioner, proving their allegation under domestic abuse, stalking, or any of the legal theories within the statute, and that they continue to remain in fear at the time of filing the petition, thus satisfying the need element for injunctive relief. I see that I'm almost out of time. We ask to reverse and remand consistent with those applicable standards. If there are no further questions.
I hear none.
Thank you, Your Honor.
Thank you.
May it please the court, Ann Short for Ms. Kasulis on this appeal. These cases are very striking bookends, looking at this statute and what is allowed. But I will say at the outright, this one does not need to be remanded. This falls under the subsection of B because no ex parte order was entered in this case. And when you read the order of protection that was applied, when you read the motion for order of protection, you'll understand why it wasn't granted. But there was no ex parte granted. And the statute is clear by using the permissive language, the court may issue an order of protection. Mr. Armitage has cited not a single case that could be construed as saying under the may provision that a trial court cannot, as a matter of law, take into consideration if there is some sort of continuing need of protection.
As part of determining whether to issue the ex parte emergency protective order, the trial judge is making a determination of some kind of danger, threat, risk to the individual who's seeking the protective order under A. Is that correct, roughly correct? What's the determination that's being made with regard to issuing the emergency protective order under, 605A?
There wasn't one issued in
No. I'm not talking about, I know one was issued
apologize.
in this case, but in terms of in general under the statute, what's the determination, the threshold determination that's being made with regard to issuing?
The threshold would appear to be that if you read the allegations to see if they fulfill that there's been some violence, some sexual violence, some fear, there's enough there beyond a mere subjective, I'm afraid of somebody. First you have that, and then the statute does kick in with the immediacy angle to it. And then, but the statute makes it clear we're talking about a 15-day window, because all you're doing at that point is just looking at bald written assertions.
It strikes me as there may be a currentness aspect under A to get the emergency protective order issued, that there's some current threat, some current risk of harm. Is by reading in the ongoing danger into a may circumstance, is the trial court really just drawing a distinction between a case where we have a determination that's already been made with regard to the emergency protective order that there is that sort of current danger versus one where we don't have that determination coming in? Is that part of the distinction here in terms of how this fits in? It's really doing the same thing. It's just doing it in A or doing it in B as opposed to A. I don't know if that question made any sense or not. But I guess what I'm getting at is under A, it seems like in issuing an emergency protective order, and the trial judge is making some sort of finding determination as to a current risk. If you don't have that order, you don't have that determination that's been made. So is it an appropriate consideration in determining whether to issue under the may to think about whether there's a current risk?
Well, my answer would be the legislature has said yes, because they have used the word may, and when a trial court is given that kind of discretion, may, and it is not otherwise statutorily limited, then there was nothing erroneous about Judge McMillan considering whether there was a continuing need. And the reason why I say we don't need a remand, two more reasons, is that his factual findings regarding no continuing need for protection, those come here with the presumption of correctness. And there's nothing been shown that would undermine his specific factual findings that there isn't a need. These people didn't go to school together, they didn't work together, they didn't live in the same part of the city, there were no other intersections, and the proof, by the way, showed that the women said after they got through telling him off, we don't want to have anything else to do with you. And that was certainly true for her. So we have the factual findings coupled with nothing to limit the trial court's consideration of that in the permissive may situation. Also, what we have is Judge McMillan said that with Ms. Kasulis holding against the will, that's a tighter case. That was the expression he used. Well, we suggest that a tighter case is not the same as concluding Mr. Armitage had established domestic abuse by a preponderance of the evidence. So we've got that conclusion. It's a tighter case. That doesn't say they've shown it by preponderance. They have the may part of it, since there was not a pre-existing ex parte order in this case. Nothing forbid him. And his factual findings, we say, Your Honor, that this order should be affirmed and that there is no need to remand this case.
Anything further? You still have a little time left.
I think that, in a nutshell, the court, obviously, from its questions, I think understands the issues very well. And as I said, these two cases are interesting bookends in dealing with this statute. Thank you.
Thank you. Your rebuttal.
Thank you, Your Honor. May it please the court, I'd like to leave you with 2 points. One regarding the may distinction and one regarding the factual findings of the trial court. The may distinction is permissive. That is established legal standard. That a shall may is regarding discretion of the trial court. However, a may language does not give trial courts the discretion to employ unsound legal standards and to deviate from meaningful standards.
Why is it an unsound legal standard in deciding whether to issue an order of protection to consider whether there's ongoing risk or danger or not? What makes that a improper consideration? I mean, isn't it broadly consistent with the purpose of the statute?
It's unsound because there is no case law to support that determination under an ongoing existing danger standard as articulated by the trial court.
Is that a matter of there's no case law either way, or is there any case law that says it is improper to consider whether or not there's an ongoing danger under the May standard of B?
Your Honor, the trial court, it is an important distinction to make that the trial court is not using the traditional elements that have been used to meet a need standard. They are establishing a new standard for ongoing existing danger that is not consistent with what's been used to establish need in the past. This trial court has said ongoing existing danger, language which has never shown up in order of protection litigation, and they're satisfying it based on the number of social social connections between the parties, which has not been testified to nor any evidence entered one way or the other. The trial court is establishing its own standard, which does not run consistent with the legal practice that discretionary decisions by the trial court need to have meaningful standards backing them. If this trial court wished to decide this case one way or the other, it needed to use established case law and established practices consistent with the statute, the legislative purpose, the definitions under 601, and the case law behind it.
The two women in this case, my understanding, it testified essentially they didn't want to have anything to do with him anymore. They're going their own way. Isn't the trial judge entitled to believe that?
Your Honor, the trial judge can take that into consideration. However, both parties articulated they did not want to see him again, and then he saw them again not even many hours later, driving past him in their car, in Ginny Hale's car. This is suspect given there were multiple cars there that night. They all got into Ginny Hale's car and then drove down the same street he was driving down. Mr. Armitage saw the significance in that when he turned around as soon as he saw them driving down the road and left the other direction. They said they did not want to see him again, and then he saw them multiple times after that the same night. There is an issue of credibility with that statement. Moreover, with Andrea Kasulis and her actions that night, the trial court made several findings of fact showing that she worked in concert with Ginny Hale to commit this abuse with the other two women. The trial court found that they stood between him and the door. They sat him at that table. Mr. Armitage would have to risk physical confrontation to leave based on where they were bracing him. It's clear the trial court saw this as two women working in concert to abuse Mr. Armitage, hold him in physical restraint, as the trial court found that I do believe he was held against his will and that it was their intention to hold him against his will. Later on, after the incidents in the car, the trial court articulates that these actions substantially increased his fear of being held, showing that the trial court believed there was fear of being held throughout the night, and that fear increased. The trial court is making the determinations that there was physical restraint and fear thereof, which is enough to satisfy the definition of domestic abuse under 601. These findings establish a prima facie case sufficient to survive a motion for involuntary dismissal. My apologies, Your Honor, I am way over time.
That's okay.
I get a little excited.
I think you presented your case fairly. Okay. Thank you both for your presentation. Your case now has been presented to this court for resolution. You should receive our opinion and judgment within a reasonable period of time. This time, both attorneys may be excused. And thank you again.